Obviously, my name is Hodis. I'm with. I don't have an issue, my lady. Just for the record, because of so many different people speaking, my junior in the matter is Neil Governor, and in this matter we are instructed by Victor Kwashu attorneys, and Mr. Kwashu is present in court. My lady, in relation to accused number 6, is her representative is present. I understand she's on her way, but we aren't involved in that, and they will be addressing you in due course in the criminal pre-trial, my lady.
Thank you. Thank you, Mr. Yes.
May I proceed, my lady?
Yes.
Thank you, my lady. My lady, as undertaken yesterday, we compiled the two chronologies. I beg leave to hand up the chronology relating to yesterday's matter. I understand my junior has given copies to the other side. And then there's also, in relation to today's matter, my lady, there's a chronology as well. I hand that to your ladyship. That's the one that's headed Magashule at the top. And I will be commencing with that one, my lady, so it'll be easier to follow the dates there rather than having to record everything. So your ladyship will see it commences, my lady, with the first date in the chronology being the 1st of August 2013. That's when Miss Charlotta commenced employment as the personal assistant to the Premier of the Free State, who was at that stage applicant or accused 13. And we have the reference in the affidavit to it in the annexure. Then, my lady, moving forward in time to October 2015, there was the ANC's 4th National General Council adopted a resolution that the ANC leaders and members who are alleged to be involved in corrupt activities should, where necessary, step aside until their names are cleared. That was referred to, my lady, as the step aside rule. We move forward to March 2018, my lady, where this applicant vacated his position as Premier of the Free State to take up the position as the Secretary General of the ANC. And the reference is there, my lady, in the founding affidavit. March 2018, the applicant is replaced as the Premier of the Free State by Mrs. Sisi Ntombela, and Ms. Charlotta commenced employment with her, that is under Ms. Ntombela as the Premier, and that's the reference is there to the founding affidavit. 30th of June 2019, Ms. Charlotta left the office of the Premier to pursue her further education abroad. That's the subject of this application. The reference is to paragraph 23 in the founding affidavit. Then, my lady, we start with the commission. On the 5th of April and the 27th of August 2019, Mr. Dukwana testified at the State of Capture Commission concerning, inter alia, the applicant, and the reference is there. 10th of October 2019 is when the investigation diary commences. That coincides with yesterday's matter as well, my lady. So it starts with instruction to obtain statements from the State Capture Commission. The reference is ESM 4, it's in our papers, my lady. Then on the 21st of November 2019, Captain Carlitz, the investigating officer, sent an email to Colonel Heap requesting information concerning Mr. Dukwana's testimony at the Commission on 5 April 2019. Also states that he is aware that none of the information obtained from the Commission can be used unless the person testified. He requested Mr. Dukwana's statement, which he wanted to consider before approaching him, and the reference is there, my lady. 22nd of November 2019, there's a response from Colonel Heap stating that Mr. Dukwana's affidavit would be loaded onto the Commission's web page and that he would inform Captain Carlitz as soon as this was done. Colonel Heap confirmed that Captain Carlitz was working closely with Mrs. Lamprecht and Swanepoel from the Commission, that he had no further information other than that which was already provided. That is Mr. Oosthuizen's contact details. The reference is there, and it's ESM 6. Then 26th of November 2019, Ms. Charlotte is summoned to appear at the State of Capture Commission. That's ESM 7 and paragraph 4. On the 5th of December 2019, Ms. Charlotte signs a statement represented by V&A attorneys. That's the founding affidavit, paragraph 23. 6th of December, she testifies at the Commission, once again represented by V&A attorneys. The reference is there. 1st of June 2020, this correspondence concerning a conflict of interest to the previous prosecutor, who is removed. 23rd of August 2020, the President, Mr. Ramaphosa, addresses letters to members of the ANC pleading that the ANC must take steps to immediately implement the step-aside rule, and the reference is there. Then, my lady, we begin with the issues that are pertinent to this matter. it's contended, and that's why we say alleged certification, because it wasn't revealed until much later, my lady. So on the 3rd of November 2020, there's the alleged certification by Advocate Samaru, in accordance with Section 27 as read with Section 34 of PRECA. Now, my lady, in order to understand that, we need to, with respect, fully understand the provisions of Section 27. I know this was argued before your ladyship yesterday, but I need to emphasize other aspects, my lady. Your ladyship will find a full citation of Section 27 in our opponent's heads, my lady. It's at page 28 of their heads, their paragraph 58. And what Section 27 of PRECA provides, my lady, as detailed in their heads, is as follows. It provides for the authorization to institute proceedings in respect of certain offences. So Section 34, with which this applicant is charged, requires, in our submission, compliance with Section 27 as a jurisdictional prerequisite. It's not a mere formality. It's not something that one can avoid. We say procedurally it's a jurisdictional procedural prerequisite. And we say so for the following reasons. It reads as follows, my lady. The institution of a prosecution for offence referred to in section, and we cut out the others, my lady, to 34.2, and then there's the word must. And must means that you're compelled or forced to. There's no discretion. It says must be authorized in writing by the National Director. We have an authorization, my lady, which we subsequently received. A Deputy National Director of Public Prosecutions or the Director of Public Prosecutions concerned. And then there's the article, my lady, that interprets the rest of the provision where it says and only. And that's what it says. So Section 27 says it must be authorized in writing and only after. So one cannot read them separately, my lady. They're joined by the article and it says, and only after the person concerned has been afforded a reasonable opportunity by the investigating or prosecuting authority, as the case may be, to explain whether, personally or through a legal representative, and then I'm going to cut to Section 34.2, which is sub C. In the case of Section 34.2, why he or she failed to report in terms of Section 34.2. So our submission, my lady, and your ladyship heard about peremptory, directory. We say, my lady, that must is directive. It tells you as a fact that you have to do it. It compels you to do it. If you look at the dictionary definition of must, it says compelled to or forced to. So you're forced to, firstly, have written authorization, and that can only be given after. It says, and only after the person concerned has been afforded a reasonable opportunity by the investigating or prosecuting authority, as the case may be, to explain whether personally or through or a legal representative, he or she failed to report in terms of Section 34.2. So we say that they're totally out, my lady. There is no possible explanation, and the Advocate summary was not entitled in law to authorize in writing the prosecution without the applicant having been afforded a reasonable opportunity to explain. It's similar, my lady, if I can draw a parallel to a bail application. In Schedule 5 and Schedule 6 bail applications, it says once the applicant for bail has been afforded a reasonable opportunity to adduce evidence. So we say you are given the opportunity to do so. So you cannot keep someone incarcerated. You have to be beyond 48 hours in terms of Section 50. You have to. It's not that you're entitled to or permitted to. You have to afford them a reasonable opportunity to adduce evidence to satisfy the court if it's Schedule 5, while the interests of justice permit, if it's Schedule 6, while there are exceptional circumstances that justify. Now, my lady, their argument, and this is in their heads of argument, paragraph 60, they say,
talk about the respondents.
Yes, my lady. Paragraph 60 on page 29, that this might have had merit if there's only one charge. My lady, I'm going to show your ladyship that when the applicant was arrested, the only charge that was leveled against him on the respondent's version, as given by their investigating officer, was Section 34.2. I will show it to you in writing, my lady. I know it sounds difficult to believe in the light of the argument, but I'll take your ladyship to that. In fact, it might be advisable to do so right now, my lady. If I may refer your ladyship to the affidavit or statement that's repeated twice in our papers. It's by the investigating officer, Captain Corlett. It appears immediately after, my lady, the authorization, which you'll see at 245. This is at 246. It's ESM 10 to our papers, my lady. And your ladyship will see it's repeated, and I apologize for that, at page 247, but thankfully it's only a short document, and it's one page that I'm going to read most of it to your ladyship. You will see that Captain Carlitz identifies himself and explains his position in paragraphs 1 and 2, and then he explains he's the investigating officer in this matter. He says of alleged fraud and corruption, and then he says on 2020-11-10 a J50 warrant was issued for a suspect. So it was applied for on the 4th, as I told your ladyship. It's now issued on the 10th of November 2020 for this applicant. His details are given there. For the charges, he says they are fraud and corruption. Paragraph 3. On 13 November 2020 at 8:20, the suspect handed himself over to me in the presence of his legal advisor, Mr. Victor Nkwashu, details, and myself at the office of the DPCR, and the address is given. Paragraph 4. After receiving the suspect and his legal representatives, the suspect was escorted to the office of my commander, Brigadier Gerber, where I arrested the suspect at 8:25 on the J50 warrant. And now I quote the pertinent part that we've highlighted in our affidavit, my lady. I placed my hand on the shoulder of the suspect and arrested Mr. Idias Sekobela Magashule on the charge of Section 34 of the Prevention of Corrupt Activities Act 12 of 2004. I informed him of his rights as a suspect according to the Constitution, and I explained to him what was going to happen next. This whole process was done in the presence of his legal representatives. Nowhere will your ladyship find that he was afforded an opportunity to give a reasonable explanation. In any event, my lady, this postdates the authorization of Advocate Somaru, which, as I've said, my lady, predates this event and is in our sequence, in the chronology of events, my lady, on the 3rd of November. So, my lady, that's Captain Carlitz's version. Let's just look what else they say in the heads of argument in support of this contention, my lady. What they then say is that it's not, as I said to your ladyship in paragraph 60, it's not a lone charge. You must read it with all the other charges. And they say it here, if we look at their paragraph 60, they say, in terms of these sections, we submit that it's clear that where alone or principal charges to pursue against a person who holds a position of authority, in terms of section 34(1) or the other sections therein referred, the authorization required by section 27(2) must be obtained prior to the prosecution commencing. In other words, where a person is only to be charged with a failure to exercise oversight, but is not otherwise charged as being complicit in the offences in question, then the opportunity to provide an explanation ought to be afforded to them. You won't find that in the provision, my lady. It doesn't say when this is a charge on its own. It says it's a prerequisite, my lady. So it's, with respect, nonsense, this argument. Paragraph 61, they continue in their heads of argument. However, Preka is silent upon what ought to transpire when, as is the position with regards to Mr. Magashule, the section 34(2) offence is merely a third alternative charge to be pursued only if the main charge of fraud on counts 1 to 8 and the first two alternative charges of theft and attempted theft fails. We submit that on the facts of this matter, particularly because the nucleus of all charges against Mr. Magashule stem from the same facts, a business-like and common-sense approach to the interpretation and application of section 27 read with 34 of Preka ought to be taken. I know of no such basis, my lady. It's a novel approach to the law that you must now look at the statute and apply a business-like and common-sense approach. It's nonsensical with respect. Paragraph 62, my lady. They say, to this end, the wording of section 27 of PREC is submitted to be directory and not
So
peremptory.
which, is that the next paragraph?
Yes, my lady. Page 30, paragraph 62 of the heads of argument. They say here it's directory and not peremptory. I don't know how they read that into the word must only and only, my lady. It merely requires the state to afford the accused a reasonable opportunity to provide an explanation. Mr. Magashule has now had that opportunity in this application. He has pursued and merely states that he had no knowledge of any wrongdoing in connection with the asbestos project. This position he adopts takes matters nowhere and with respect would have had no impact had his response been given by him if the state had afforded Magashule the reasonable opportunity referred to in section 27. My lady, if he'd been given the opportunity to explain as is required by law, he might very well have said this doesn't fall under my ambit of responsibility. Somebody else dealt with and identified that person, but he was never given that opportunity, my lady. So one cannot say, well, now you've had every opportunity after the fact, but it says, and only after. I need to remind my learned friends, my lady. Paragraph 63 of the heads. And this is where we go from the ridiculous to the sublime with respect. Further, were the state to have afforded Mr. Magashule the opportunity to explain why I failed to report an offence referred to in section 34 as envisaged in section 27 of PRECA, this would have potentially violated his constitutional right to remain silent in respect of the principal charges which are inextricably linked to the alternative charge, if indeed he had chosen to provide an explanation for his failure to report. Furthermore, he may have taken steps to evade justice on the other more serious charges he faces, made multiple approaches to the courts to delay prosecution or otherwise have interfered with the investigation. One lady, what they're saying is, because you're afforded a reasonable opportunity to explain, that creates a type of a reverse onus that compels you to answer or compulsion to answer. It doesn't. It says it affords him a reasonable opportunity should he choose to explain. There's nothing unconstitutional, irregular, improper, and if they're of the view that it is, then it was up to them to review it and set it aside or make out such a case. The last thing that we've seen them doing thus far, my lady, is protecting the constitutional rights of an accused, and more specifically that of the right to remain silent. So it's preposterous to now contend that we didn't do it because we were afraid that we might have potentially interfered with his right to remain silent. It's an after the fact attempt to justify conduct that is clearly wrong. Paragraph 64 of their heads, they say, in any event we submit that the state's non-compliance with section 27 of PRECA is not fatal to the criminal proceedings in relation to the alternative charges pursued against Mr. Magashule in terms of section 34 of PRECA, but at best would rather merely delay the proceedings pending compliance with section 27 thereof. That's ridiculous, my lady. If the arrest took place, as Captain Carlos on his own version says, solely, and I quote from their heads of argument, my lady, on the section 34, then everything after that is tainted and falls by the bar. Put differently, as they say, fruit of a poison tree, and we do have that concept in our law, even though we do allow for people to be forcibly examined despite their constitutional rights as provided for in the Criminal Procedure Act. Now it gets even better, my lady. In paragraph 65, they say, but if Mr. Magashule is intent on arguing that the state has failed to comply with section 34(1), read with section 27 of PRECA, in that the authorization has been issued prematurely, that we submit is a matter that ought properly to be raised by way of a special plea being taken by Mr. Magashule at the commencement of his criminal trial in accordance with section 10618 of the CPA, which provides when an accused pleads to a charge, he may plead that the prosecutor has no title to prosecute. My lady, that is, with respect, pushing a square peg into a round hole. It doesn't fit. Section 10618, my lady, deals with the prosecutor who lacks title. It doesn't deal with the procedural irregularity where the state is not compliant with the Act. 10618 seems to be the new fashion, my lady. It was adopted in Pietermaritzburg. It doesn't fit here. It was used there to attempt to get Mr. Downer to step down from prosecuting because of his possible bias in the matter, and it's been was found to be unfounded. But in any event, it doesn't fit here, my lady. We do not, and I want to make this very, very clear, we do not take issue with the title of the prosecutor. We have never done so. We've never recorded it. We're well aware of the provisions of Section 106 that deals with all the special...
I'm just wondering whether, by extension, you're attacking the authorization, the certification after or without giving the person an opportunity to explain, means that the certification is void or not valid. Therefore, the title of the prosecutor. I'm not sure.
No, my lady, they're two distinct arguments. No, and I want to explain that because that's what they attempt to do, and we say there's no merit in it. The 1061H procedure envisages where you say to a prosecutor, you are not entitled to prosecute because you weren't properly sworn, you haven't taken an oath of office, you're overstepping your mandate, you are not a qualified prosecutor. It was used by way of example, my lady, in the Benuli matter. In Benuli, it was a matter in Pretoria in front of Judge du Plessis. Ben du Plessis held that private members of the bar may not prosecute because they have a different approach and ethical obligation in matters. So he said it was constitutionally impermissible to allow somebody who's paid in a matter to win the matter to take the position of a prosecutor who's meant to prosecute without fear, favour or prejudice. So that was the distinction. That's a 1061H classical example, my lady. The failure by the state to obtain the required certification, as we have seen in other matters, my lady, where charges of racketeering are proffered against people and they review the racketeering charges, not once have any of them, my lady, challenged the title of the prosecutor to prosecute. That's a totally different argument. It doesn't fall under 1061H. That's why I say, my lady, without any doubt, that it's comparable to pushing a square peg into a round hole. It doesn't fit. Attractive as it might appear to my learned friends to be, it just simply does not fit. Not in law and not in fact. They are clearly distinguishable. In fact, my lady, if one looks through the possible pleas in terms of Section 106, one will not find a possible plea that deals with the failure to certify. It's not a plea, my lady. 106.1 sets out, my lady, all the possible pleas, and it doesn't cover, with respect, the failure to certify or to follow procedural requirements, or the failure to do one's work properly. If we can do an analogy or an illustration of it, my lady, if we take a drunken driving case, it would be comparable to charging somebody for driving under the influence of alcohol without, in terms of the statutory offence of exceeding 0.05, it might have changed. I apologize, I haven't done for many years, but it would be comparable to doing it without having the medical certification. It's a non-starter, my lady. Same as charging somebody with a drug, be it Mandrax or ecstasy, and not having the proof that the substance is in fact the drug that they say it is. So if you say somebody dealt in Mandrax and a white powder is brought to court, but it's not proven to be Mandrax and it could actually be Disprin, it's a non-starter. One doesn't get past the beginning, and it's not a special plea. It's a procedural irregularity. It's a jurisdictional prerequisite, if I may use the terminology, to such a prosecution, and one cannot begin the trial without jumping through those hoops. And the judge president and I'm straying from my chronology, but I will get there, my lady. But I can tell your ladyship now that the judge president said these are the hoops that you have to go through in order to pursue such a charge against an accused person, and it's a simple yes or a simple no. But as the record will reflect, and I'll take your ladyship there very soon, there was no answer forthcoming in that regard. So, my lady, going back to the chronology, the second important date here, my lady, is the 18th of November 2020, where there was email correspondence between Ms. Charlotte and Advocate the Nation, where she records that it was clear that she had no choice concerning being a state witness. Now, the reference to this, my lady, is AA1 on page 469 of the record. So it's apparent, my lady, that this is attached to the answering affidavit. And it's going back to Charlotta, the state witness, which we will deal with in due course, I'm sure your ladyship. And it's fully dealt with in the papers and the heads of argument. So AA1 is their attachment to their answering affidavit. As is the fashion with emails, my lady, the email at the bottom of the page precedes the email at the top of the page. So it starts with an email from the investigating officer to Ms. Charlotta, I beg your pardon, from the advocate, from Advocate the Nation to Ms. Charlotta, and I will just read to your ladyship the last two paragraphs. It says, the attorney of Mr. Magashule sent us a letter a while back indicating that he is representing both you and Magashule. Since the latter is now an accused, there cannot, as dictated by law, be contact between the two of you, or between his attorney and you, or by anyone acting on behalf of the accused or his attorney. They were under the impression that you were a future accused, which position I had to address in court. I also had to put it clearly on record that you are a witness for the state, and requested the court to note a bail condition that they not make any contact with you. Your testimony will revolve around the so-called asbestos matter. I understand your fear for having to testify about something you do not have the full details about, but please rest assured you are but one of a great number of witnesses. In a much bigger picture, I will not expect you to testify about aspects that you do not have knowledge about. Now, if I can contextualize this, my lady, when the applicant was arrested, he was brought to court, there was a bail application, and your ladyship will know from the papers that on 13 November 2020 it was recorded that Ms. Charlotta is a state witness, and the accused, as a condition of being released on bail, may not have any communication with her. The last paragraph on this page, my lady, it says, your testimony will revolve around the so-called asbestos matter. I understand your fear for having to testify about something you do not have the full details about, but please rest assured you are but one of a great number of witnesses. In a much bigger picture, I will not expect you to testify about aspects that you do not have knowledge about. So it's clear, my lady, unbeknown to us, we haven't seen this prior to this, Ms. Charlotte at that stage had not provided a statement, had not even given details of anything that she might provide evidence about. And the date is important, my lady. This is on the 18th of November 2020, bail having been set with a condition and it having been recorded in open court that she is a state witness on 13 November 2020. But the most insightful part of this document, my lady, is the subsequent or the trailing email at the top of the page where Ms. Charlotta, later that evening at 20:48, on Wednesday the 18th of November, responds as follows to Advocate the Nation. Good day, sir. I hereby acknowledge your correspondence with appreciation. I thank you for the clarification in this regard. It is loud and clear that I do not have any choice. I can assure you my 100% cooperation in this matter solely because I respect the law. I will definitely appreciate a copy of the affidavit when you are ready. Going forward, I will hear from you. So you can see here, with respect, my lady, with hindsight, there was some type of a negotiation, and we will take it further because we were given more information later. There was some type of a negotiation and some formulation of an affidavit that was contemplated that says that one could not, with respect, have said, this is a state witness, you may not communicate with them. More specifically, my lady, it cannot never be argued that the investigations had been completed at the time of the arrest, which goes to the timing of the arrest. Because going back to the 70s, my lady, we have the decision of State versus Bennett that one does not arrest until the investigation is complete. One cannot come to court and say, we trial ready, let's go to court, let's have a trial, well knowing the investigation is not complete. These are principles of fairness in our law. They clutter up the roles of the court. It's a requirement, my lady. And one can see here, it's evident, my lady, that the state was not ready and the investigation had not been completed as at the time of Mr. Magashule's arrest, even though, and I won't put it stronger than this, the Judge President did with respect, but even though it is quite apparent that a final affidavit or statement from Ms. Charlotte had not been secured, and one could not have said, she is a state witness, we have a statement from her, because they didn't at that stage have one. It's apparent. In fact, she was still uncertain as to what she was required to say to become a state witness, as will become more apparent as we proceed here. So, we record in the chronology here, my lady, that on the 18th of November, 5 days after the arrest and release on bail of the applicant, Ms. Charlotte recorded that she had no choice concerning becoming a state witness. Now, my lady, on the 7th of July 2021, we were compelled, and I use the word, in other words, that we were forced to launch an application to compel the state to provide the B&C sections of the docket. Your ladyship will know from the papers and the correspondence, there are numerous requests for the B&C section of the docket. They didn't provide it to us. Eventually, my lady, we launched an application. On the eve that the application was about to be heard, they capitulated and gave us the B&C sections, as we're going to get to in the next thing. So, your ladyship will see the references there, the founding affidavit and the correspondence is there. And your ladyship will know, based on the decision of Shabalala versus Attorney General of Pretoria and others, as well as the other leading authorities in this regard, my lady, that the state was obliged to give us the B&C sections unless they could make out a case that they didn't have to, or there was privilege over specific parts of the docket. The matter was set down, my lady, for the week, as your roll works here, of 19 to 23 July. No opposition had been received. We were about to leave, and on the eve of the 19th of July, just before the matter was to be heard, the state capitulated. And I use that word in every sense of the word and with intention. On the eve of the High Court application to obtain the B&C sections of the docket, but refused to tender the cost, the state says that it was unbecoming of officers of the court to have brought that application. So I will show you that reference, my lady, it's in the papers here. They, and this will go to the striking out application, my lady, they say it is unbecoming of officers of the court to apply for the B&C sections of the docket. Nothing could be further from the truth with respect, my lady. We were entitled in law to it. They capitulated and gave it to us, and there's no authority to say that we did anything wrong as officers of the court in applying for the B&C sections of the docket. It's got no basis with respect, my lady. It's groundless. Now, my lady, we go back to the situation with Ms. Charlotte, and we've subsequently established, my lady, that on 22 October 2021, Ms. Charlotte attended an interview with Brigadier Gerber and Captain Carlett in Washington, D.C. My lady, this was circulated on the internet, and it was typewritten and appears as RA1, which is the first annexure to our replying affidavit, my lady. And I only need to highlight certain aspects, my lady, because it makes it somewhat even more confusing as to what the status of Ms. Charlotte is. And your ladyship heard that she's been extradited and added as an accused, and there's some version of the indictment that refers to her, my lady, as being the 17th accused. So I wish to refer your ladyship to RA1, which commences at page 536, my lady. And I'll be very brief, my lady. Your ladyship will see at 536 is the date. And it's held at Washington, D.C., USA. It's an interview.
Mine says 537. Okay. It's not serious.
I think it's 536 and 537. Mm-hmm. There's a cover page at 536.
My 536 is the page where the attestation of the replying affidavit.
I apologize. My junior is the same as you. I don't know how that happens. I apologize, mate. So it's at 537. Your ladyship will see that it's an interview held at Washington, D.C., USA. The date is the 22nd of October 2021. As interviewer, there are two people identified, a Brigadier Nico Gerber and a Captain Benjamin Carlett, the same captain whose statement I referred your ladyship to. And the interviewee is Miss Muradi Choloto. If one turns to the last page, my lady, of that interview, which on the corrected version of the record, my lady, is page 618, your ladyship will see that there was an interview of the procedure and what's going to happen, and then explaining how one does these interviews. But this is how the interview ends off on the 22nd of October 2021, my lady. I'm going to take it from the top just so that we can see. So Ms. Choloto says it does not work like that. Brigadier Gerber says his designation and things so. She says, I'm just asking. Captain Connor says, yeah, we are just saying. Ms. Choloto says, Brigadier Gerber says, okay. Ms. Choloto then says, thank you very much then. Brigadier Gerber says, thank you for that, appreciate it. Ms. Choloto says, and Brigadier Gerber says, then we will see you tomorrow. So it seems, and I cannot put it stronger than that, my lady, that there was some element of cooperation or working together, be it under compulsion, because she says she had no choice, whatever the situation is, that they were going to meet the next morning, but I don't know what happened after, because they've never told us what happened in relation to Ms. Choloto.
Whether the meeting did take place or not, is that what you said?
As your ladyship is, yes, my lady. My lady, the last date in our chronology, in what I had alluded to previously, was the 3rd of November 2021, and this is the Judicial Pre-Trial Case Management meeting before the Judge President, the Honourable Mr. Justice Musi. This is a transcript that's attached to our papers as RA5, and I need, with respect, to take your ladyship through this, where I believe the case is made out on both of the points that make the relief sought in this matter evident, my lady. I have it in at page 660 there, so we have the same page as Chaplain. So, my lady, RA5 commences at page 660. Your ladyship will be able to identify that this is the pre-trial. The ladyship will see on...
Sorry, 600.
660, my lady.
Oh, 66.
So your ladyship will see on 661, I recorded in this court that we have objections, and your ladyship will see this in line 15. Accused 13, which is this applicant, also associated objection, my lord, that was to the Judge President, notified the state that they have not complied with section 27 of the Act, which required certification prior to the institution of those proceedings in terms of poker. My lady, so we have given them 2 notices, and then you'll see further down the page, the one was after the other, but they were both related. So accused number 13, my lord, takes the point, and my lord will remember from the first pre-trial meeting, we said that there is a debate concerning the status of Ms. Choloto. He says yes. I say the state contends that she is a state witness. We said there's a defense witness before we had a signed statement for her. In my term, you must excuse me. So they have attended at the State Capture Commission on her behalf and represent accused 13. They were both involved at the same time, instructing the same attorney, and we recorded that when we received the docket, it was clear that the statement had not been signed, even though they claimed during the bail application that she was a state witness, that they are not entitled to communicate with her. That is another issue, my lord, with respect, and I submit must be resolved before the plea stage, premised on the principle, my lord, that the accused is entitled to know the case that he has to meet in terms of section 35 of the Constitution, that is accused 13. At the foot of that page, my lady, I say, my lord, the objection is based, in summary, my lord, is based upon the docket having been opened subsequently thereto, as we have revealed after we brought an application to the High Court here, my lord, for the, and it should read B and C sections of the docket, and 2 indistinct, which then strengthened our suspicions and confirmed that in our submissions, and I know that my opponents dispute this. Then we turn to page 664, my lady. If your ladyship would have regard to from line 17 to 20, where we made it clear, my lady, I said as follows: I'm not looking at a Section 106 special plea or anything like that. These are preliminary issues that go to the fairness of the trial, my Lord, and I respectfully submit ought to be resolved before we go to the plea stage. If you then turn the page, my lady, to page 665, the last 3 lines, we will need to resolve this upfront, my Lord, because it goes to the fairness of the trial. We do not want to start a trial with 23 odd, I might be incorrect on the number of accused. It would then be considered an interlocutory application to determine the fairness of the trial while everybody is waiting in abeyance. We turn to page 668, my lady. The Judge President says in line 6, all right, good. And then they say that, or the allegation at this stage is that the state does not have the wherewithal to charge them because in terms of the Act they were supposed to get some time in order to give an explanation. And in terms of the Act they may not be prosecuted if that has not been done. That is their argument. Now, has that been done? Because that is an objective thing, and it is either they were asked or they were not asked. And that's the Judge President directing a question to the state. Advocate the nation answers, my Lord, we did not want to broadcast the intention to arrest certain people. The main charge, the one of fraud, the accused would in any event have been arrested for fraud. The contravention of section, it should be 34, it says 24, it's a typo, is only an alternative count. The accused also adamant to give some or other reason, they can still do that. Then his lordship says, no, Mr. The Nation, please. I think section 27 is clear. It says that if you want to institute a prosecution in terms of section 34.2, there must be first the authorization in writing. Now they are asking you, do you have authorization in writing? And if so, favor us with a copy thereof. You cannot just say, well, it is an alternative charge. The fact of the matter is it is a charge. Then secondly, they say in terms of the Act, they were supposed to be afforded an opportunity to explain. They were never asked to. So you cannot say it is an alternative charge and therefore there is no need to ask them that. Then Mr. The Nation says, my Lord, I shall file proper and comprehensive papers in this regard because it is a formal application. I need time to file proper and comprehensive answer to. Now, my lady, this goes to the fact of whether this is the right forum to be arguing this, because here you have the state requesting the right to file papers in a formal application. Then the Judge President says, no, Mr. Advocate the Nation says to those allegations. The Judge President says, no, Mr. The Nation. As I understand the Act, maybe my understanding of it is wrong. It says before you institute the prosecution against them, you must have authorization in writing. So therefore, the step of instituting the prosecution against them, whether by way of an alternative charge or by way of a main court, should be preceded by a written authorization. And they are saying, well, now that we are here, we are charged with this, especially accused 6. Although his legal representative puts it much wider, he says, well, now that I'm here, I'm charged with contravening the section, but I've not been favored with a copy of the written authorization. And if there is no written authorization, there cannot be any charge. That is how I understand it. Now, it is either you have the authorization or you do not. And here we hear for the first time, my lady, Advocate the Nation says, I have the authorization. The court says at this stage the Advocate the Nation says, I understand it. The main problem is that the fact that they were not offered an opportunity to give some other reason. Judge President says, no, they say, Mr. The Nation says, or there is none reported. Judge President says, they say there was non-compliance on section 27 of the Act. Mr. The Nation says, yes. Judge President says, so in order to comply with section 27, there must be a written authorization. They actually request that in so many words. I think accused 16, where is it? Yes, paragraph 2 of the notice, and he quotes it, my lady, to the next page, and he quotes, he says, they seek the written authority in terms of section 27. I continue, my lady, from line 6. That is what they are asking. So it is on both legs that they are saying the state has a problem instituting the prosecution against the accused. It should be 16. I know the record says 6, my lady. At this stage, although his attorney says any of the accused, but I think it is, we can lower it to accused 6. Should say 16.
But at that stage, was he accused 16?
16, my lady.
Unless the court is making an error. Is he not accused 30?
No, we 13. This was not our notice, my lady.
Oh.
This was the notice your ladyship heard
Okay.
the other applicant yesterday. It was then their application, my lady. Okay. So then Mr. Nation says in line 11, but can I say, and I say again, this document was signed on the 29th of October. Court says, Mr. Donation says, I received it yesterday. I need time to prepare documents by replying to it. But that 29 October is to the notice, my ladies, not to the authorization. I don't want it to be misread. But that is where and then he says, I need time to prepare documents by replying to all of this. So there again, my lady, it was envisaged that we'd be having an application like this. He says, which I shall do. Then the judge president says, but that is where I have a problem. Is it a reply or just to supply the documents? Because all that accused 16 wants at this stage is a letter or email confirming that you have been given authorization to prosecute him. Then secondly, whether he was given an opportunity and whether there are any letters stating that he was given afforded opportunity to state his case before institute or before charging him of the crime. Now that cannot take so long, Mr. Donation. You have it, give it to them. Mr. Donation says, I shall. And then he undertakes on the next page to give it as well. And then the court says, yes, by when will you give it to them? Because we cannot work on you saying, well, you must prepare documents. If you have the documents, just give those who are charged with contravening Section 34 parking. Let us get this trial underway. Mr. Nation says, I shall do so. The judgment said, this day is only accused numbers 1, 3, 4, and 13 that have objections that need to be dealt with prior to plea. And then Mr. Donation includes number 16. If your ladyship would then turn 2 pages to 674, the Donation in the 4th line says, we have sent the detective to the US some time back. They came back and they reported to us that in a nutshell, Ms. Charlotte is not, I think the word missing is cooperating, my lady. She's therefore not a state, or cooperating as a state witness for the state anymore. In this circumstance, they had no choice but to sign a warrant of arrest for her, and we are now busy with the process to get her back in South Africa. So that is the position. She is a suspect, soon to be an accused in this matter. I shall add her the moment she gets into South Africa. If there's some kind of a hiccup and we cannot get her here timelessly, then the state will have no choice but to proceed without her. Now, my lady, it's important for me to record the following. This was the first notification that Ms. Charlotte was not a state witness. So we have the following situation. 13 November 2020, we have a bail application. We're informed as a fact Ms. Charlotte is a state witness. 3rd of November 2021, before this very court, we were informed for the first time that she's not a state witness. So there was no notification to us that you can now communicate with us. It's no longer a bail condition. We only find things out as things change, as I explained to your ladyship, in court. So the judge says, okay, says, but that is the position. Mr. Donation, line 19. She left us with no choice, unfortunately, and that is the position. The judge says, all right, so the issue of Ms. Charlotte is then a dead letter. It's not something that you pursue further if they're going to charge her with the other accused, because then the issue of whether she's a state witness or defense witness does not arise. She'll then be an accused person. I said, no, my lord, with respect, and I explained myself. I said, it's more serious than that. During the bail application on 13th of November 2020, we were informed of the fact that of record, my lord, the Ms. Charlotte as a state witness may not communicate with them. There could not have been truth at the time, my lord, and the light was just said. It shows also, my lord, that the state then feels if there is charges that was contended then were premised on the evidence given by Ms. Charlotte are clearly not ready for trial. I do not know how my learned friend tells your lordship we're in the process. We are going to arrest somebody, extradite her here and charge her, but we're ready to go to trial in any event. To say we've got now a person who has moved from being a definite state witness to a suspect because of a non-cooperation to yet to the trial. They were mutually exclusive of one another with respect, my lord. I then engaged with the judge and says, why do you say so, Mr. Hodis? I say, because, my lord, either she was a witness or she was not. It's quite clear now that she was not. He says, no, they say she was a witness. That is why they sent a detective to the United States of America. They could not get a statement. Do you remember on the last occasion, but one, you informed me that you have or Mr. Victor Quash has an affidavit by the person, the state prepared a statement which he did not sign, and that is basically all that we had about the witness. Now Mr. Donation is saying, well, we are jettisoning the witness, we are not going to call her anymore, but what we are going to do is we are now going to cause her to be arrested and to be added as an accused in this matter. So why do you say that matter is still a live matter? And then his lordship says, and this is where words are attributed to me, my lady, but it's not me who said this at line 10. The judge says, if you are saying, well, the state was dishonest in the bail application, that does not change the situation, that she's an accused person, and therefore the statement that you have or the affidavit that you have and the statement that they have can be used against her or not be used against her, but that is a matter for the trial court to then decide, not so. He says, how is that still something that must be entertained by way of an objection? Is if that state says she's no longer a state witness, we're not going to call her anymore. As a matter of fact, we want to have her arrested. I say, my lord, if I may just trace the background and explanation by the state. He says, yes. I said, the first time that my attorney or our clients heard that Mr. Notza is no longer a state witness, it was now. He says, yeah. We carry on about this, the state witness, my lady. And if I can take your ladyship then to page 679, my lady, line 18. So on the 3rd of November, that is the case. May we go back to section 27, my lord. And I know it's beyond what your lordship said, but my learned friend has not answered your lordship. Because section 34 charges have section 27 as a prerequisite. And the prerequisite, the two things they have to do, my lord, is get a certification and even file the certification and approach the accused for an explanation. Now your lordship has asked him 3 times. These are objective facts. Did they happen? It was time to file an answer that he should be in a position with my lord as prerequisites to state yes or no. They were approached for explanation because I'm telling your lordship as a fact, as an officer of the court, the answer is no. The charges cannot stand, but he has not answered your lordship yet. It is similar to the situation I had with Mr. Lotta. So that it has not happened, and then my lord, in order to be able to charge a person in terms of section 34, you have to be in a position to furnish that certificate up front, not say, well, I filed it, or we will go and approach them now, as he told your lordship. It's indistinct. Not he says, well, we will still go and see them, and your lordship said no. This was meant to have been done in advance. It has not happened, my lord. So it is improperly before this court. It was not to be there, my lord, to be there, but he has not answered your lordship. And with respect, my lord, I'd like him to answer through your lordship whether he contends that my client's accused, and I made a mistake, he corrects me, 13 has been approached and asked for an explanation, because I'm putting on record that it has not happened, my lord, thank you. His lordship says, but I assume that it also did not happen with regard to accused 16 hours, they would not file that notice, and then we agree on that. At the foot of that, page 681, my lady, line 21, Advocate Donation says, my lord, I'm not 100% sure. It's about the receipt of a letter. There is a huge number of documents sent to us on a weekly basis, but I find that I apologize to Mr. Kramer, but the answer to Mr. Otis from the authorization has been given. The request for the opportunity for an explanation has not been asked to answer those 2 questions. So there we finally have the answer, my lady, at the pre-trial on the 2nd of November 2021, that these prerequisites have not been complied with. We therefore say, my lady, that there can be no doubt about the fact that one cannot approach this in a businessman-like manner or a practical manner, or even as his lordship, the judge president, said, by saying, well, this is just an alternative charge, so it's different, so therefore you have the right to ignore that provision of the act. We say there is non-compliance, my lady, and it goes to the root of everything here. My lady, we've made out the case not only in the affidavits but in the heads of argument as well. We submit that you're entitled to the relief sought, my lady, with costs, my lady. It's clear, my lady, that if the arrest was in terms of section 34, as Captain Cole had said, that everything that occurred thereafter it flows as fruit of the poison tree, which does form part of our law, my lady. My lady, I then think it would be best for me to deal with the striking out application because we've left everything to this stage and I had addressed you later.
Well, I see that it's 11 o'clock. You have been on your feet for about an hour.
I can deal with it
that's
in
fine.
answer to Mr. Casson because it's his application.
Well, either way, we'll resume at say again, I can't hear you.
I think it's better if it does it in his reply. I'll use it.
Okay. Good. We'll resume. Then we'll take the tea adjournment now, and then we'll resume after. So before we do, are you complete with your?
Yes, my lady. I was turning to the striking out
Okay.
application.
Then we'll do that after tea. Thank you. Court will adjourn.
prosecution element of the process.
My lady, is that no prima facie case has been made out against the accused, and in these exceptional circumstances where your ladyship has heard what happened with Ms. Chilotta, and we put in the papers what Mr. Duquano says, but he's not on the list of witnesses. In these exceptional circumstances, we believe that the state should be ordered to give us a list of witnesses that implicates our clients.
Thank you, Mr. Kessler.
My lady, two points before I start my argument. The first is I will need more than half an hour.
Yes.
I'll try to curtail it within an hour.
Well, seeing as that Mr. Hodis was on his feet for over an hour, I'm sure you will need more than 30
The
minutes.
second, my lady, is that I appreciate, together with my team, that the accused has had his credentials in the struggle and as a member of the ANC are commendable. We do not want to unnecessarily, in any respect, demean his dignity and his contribution as a South African citizen. We respect that. I'm mindful of that. Also, in my address, if I overstep the mark, I ask you and my colleagues to please forgive me. Mr. Hodis is an esteemed counsel, and I consider him a friend. His junior has been my junior countless times, and we are family friends. But having said that, you will appreciate that I represent the public interest, and in my respectful submission, public interest must reign supreme. I must do my job serving the public interest to the best of my ability. So this is my argument. My learned friend spent, and I kept a close note, almost 15 minutes on matters which are moot, and I'll tell your ladyship why, and which I do not want to revisit. He read out from a long transcript his debate with the judge president, and it ends up this way, my lady, at 674, where the judge now is fatigued in this debate, and he says,
Sorry, 674.
674 at the bottom.
Just give me a minute.
This is on the 3rd of November, if my understanding is correct. This is now 3rd November 2021. It's 3 months ago. Lordship is exhausted after going through this debate. He says, all right, are you there, my lady, at the bottom, right at the bottom.
Yes.
So, Mr. Hodis, the issue of Ms. Cholota is then a dead letter. Why does he revisit it? It is not something that you pursue further if they are going to charge her with the other accused, because then the issue of whether she's a state witness or defense witness does not arise. Well, that's moot. Of course, my learned friend doesn't take his standing down. He carries on, as he read out to you. After the JP tells him this is moot, and then, my lady, this is what he says. Then, my lady, you see at 678, because it's a long debate now. So all this is not painting the state.
Sorry, just a minute, Mr. 6, 7, 8. So
He's not going on and on, my lady, about something that's moot, and he's just trying to say, painting the state in a bad way and why he's right in everything. Well, so be it, says the judge. At the end, at the bottom of 678, the court, this is line 5. Your client called bail. He is here on bail. So that issue is neither here nor there. This is on the 3rd of November. And he goes through all over again.
Sorry, Mr. Cassim, which line are you reading?
I'm reading from line 20.
Line 20.
678.
Yes.
And then he continues. And then at 672, 679, my lady. Line 1, 2, 3, 4, 5, 6, 7. You have all that. I'm saying you have no cause of complaint anymore. How clearer can a judge president be? 3 times he admonishes counsel. Please move on. Now he spent 15 minutes, and I kept track of this particular line. 15 minutes revisiting it. What does your ladyship do about it? So, my ladyship, what is this application all about? Please turn to prayer 1 of the notice of motion. My learned friend says, this is what they want. Declaring that the state has not complied with section 27 of PRECA and as read with section 34 thereof. Of course, today when he argued, there's a quantum leap, a case which I have not come to meet. He wants all the charges withdrawn. I can say with a measure of comfort, because I can demonstrate this, they have not properly read the docket nor the charge sheet. Had they read the docket, they would have seen A99, which is the application under section 43 of the Criminal Procedure Act for a warrant of arrest. Application is hereby made for the issue of a warrant for the arrest of Mr. Magashule on a charge of corruption, contravention of section 34, of Act 12 of 2004. We've dealt with that before. Contravention of Section 3 of Act 12 of 2004, and contravention of Section 4 of the Prevention of Combating of Corrupt Activities Act 12 of 2004. Those acts, my lady, those sections deal with general offenses of corruption, Section 3, 4 offenses in respect of corrupt activities related to public offices. Had they read the docket, they would have seen the statement regarding the interview with the suspect. And in the interview with the suspect, the very policeman they tried to malign by saying he didn't do a proper job. You will see.
I didn't hear you. I didn't hear you.
The very policeman is saying that the policeman that didn't do a proper job. There's an interview with the suspect. And again, my lady, I don't want to read it. I have informed the suspect that I hold the above mentioned rank in the South African Police Service, and I'm investigating the alleged offences. And there you have it, Section 34, contravention of 3, contravention of 4 of bracket. And of course, my lady, accused is given an opportunity if he wants to say anything, and he declines, which is his right. So, factually, my learned friend put the wrong facts before you, but opportunistically, he wants one to now result in everything being squashed. Now, of course, my lady, any seasoned criminal practitioner knows that this is dealt with under Section 106(1)(f) of the Criminal Procedure Code. That section says, when an accused pleads to a charge, he may plead that the court has no jurisdiction to try the offense. Now there, my lady, when I heard my learned friend's argument, it's persuasive. What he's saying, my lady, this falls in the mold of the South African Defence and Legal Aid case. It's a famous judgment, my lady, versus the Minister of Justice. It was Justice Corbett then sitting in the Cape Town High Court, 1967, 1 essay, Cape Town. But I haven't got the citation, but it was upheld on appeal. Where his lordship says that if it is properly construed as a jurisdictional fact and you haven't complied with, then whatever follows bears the consequences. In this case, my lady, the third alternative count, to count 1 to 8, and I'll take your ladyship through that shortly, will then be set aside. But it is at that stage so that the parties can properly prepare. You don't do this what you're doing now. Because the Criminal Procedure Act, as your ladyship knows, is bespoke legislation. You can't jump the gun. When you're pleading, you say you've got no jurisdiction and it's dealt with there. If I ask your ladyship to please turn to the charges, it might be useful now just to deal with the charges. Your ladyship will see that starts at 319.
Just a minute.
And again, my lady, I don't want to take too much of your time, but there's a whole preamble. And what the preamble tries to set out, my lady.
Sorry, what page are you talking?
It starts at 319.
Of this record, 319 of the Magashule application.
And what the preamble does, my lady, it sets out as one would
Sorry,
expect.
Mr. Kasim, I've got to keep up with you. And I'm referring to several files here, right? I'm with you.
Of the file of accused 13
Yes.
or applicant number 13. It's one of 3.
So I'm at page 319, you say?
Yes, there you'll find the indictment. And what the preamble does, my lady, it sets out the legal framework of tender law in South Africa. And I don't want to repeat it, my lady. 217 PFMA Act, Treasury regulations, chain management policy, etc. the whole thing. And of course, my lady, why the Premier at the relevant time is charged is because, my lady, there is in a democratic state called accountability. It's one of the pillars on which Section 217 is based. And of course, my lady, a Premier, my lady, is dealt with in 125 of the Constitution. He is the executive authority of the province, and under 125(2), it is his job 152B, implementing all national legislation within the functional areas listed in Schedule 4 or 5. In other words, the buck stops with him. Of course, he has defenses, and I don't want to analyze that now. Under 125(3), he may well have a defense, but that he has a case to answer, I would have thought both in law and in the democratic accountable sphere. A contract of 250 million is no small change when the true value, not following a competitive process, is 20 million. Surely if he can explain to his constituent sitting in the Free State, where we know there are roads that are untarred, we know that children have to suffer the plight of sewage in the roads. If he can explain to his constituency why he should not be held accountable, then he has a political future. But his opportunity is to deal with the matter. And that is what counts 1 to 8 deal with. It deals with fraud. Because this whole transaction is a fraud. Now the last thing your ladyship wants to deal with is the criminal trial today. It's not your ladyship's task, it's a trial court judge. But I accept, my lady, that there is an alternative count there. Let me just find the alternative count. The third alternative count. The third alternative count, my lady, my note says, is failure to report. So, my entire learned friend's attack, and on the judgment of Mr. Justice Corbett in the South African Legal Aid Fund case, his argument is persuasive that those are jurisdictional requirements. You give the person an opportunity before you charge. If a court says that's a jurisdictional requirement, then my argument about around it will fail. But that's what the trial court will do, because it goes to the section under the Criminal Procedure Act. That's a fight for another day. Then, my lady, the third alternative count, to count 1 to 8, will fall away. But of course, this morning he wants everything to go. He doesn't ask for that in the notice of motion. I haven't come here to fight that case. It's furthest away from my mind, because then you would have had a complete different answering affidavit, which I'm entitled to. Even though I act for the state, I'm still entitled to be heard properly, be given proper notice what their case is, and we would have dealt with that. But that's not the issue. Of course, my lady, he is then charged also with corruption, counts 15, 16, 17, 18, 19. And I don't want to deal with that. It's not the right place. But if you look at count 15, and if you look at count 15, it's about monies made available to one Mfilu Mokwena, who sat in this very division as a judge. And if I may just ask your ladyship will see...
Acting judge.
Acting judge, correct, my lady. There's a whole series of emails. Just to give your ladyship a flavor, there is a case he has to answer. The emails, I read them last night again, my lady, but I don't know if I made a note of the pages. Perhaps if my attorney can say, it's an email that follows after the email of Ms. Chalata. But you see that email, she writes, she says, "Dear Premier," perhaps I should just, I don't want to just tell you what the email says, it can be much more precise. Oh, there my junior found it. At 471, because you know, they complain, they say they don't know what case they have to meet. When I read this, I understand exactly what it's there. It starts at 471. The papers are put up by you. The docket's got much more, but look what it says in 471. It's on the 18th of August 2018. I think she was then acting here, my lady, as a judge, if I recollect correctly. Dear Mr. Moradi, many thanks for all your patience and kind assistance. On behalf of my family, I take this opportunity to thank every one of you who made the generous contribution towards my daughter's fees. Please communicate my heartfelt appreciation to the Premier and the donors. I'm truly grateful to the Premier for making it happen. And of course, my lady, it goes in that vein. These were fees for a daughter who was studying abroad, my lady. Quite large sums of money when you want to study in the dollar environment. But it goes on that vein. So, she writes on the 17th of July, Dear Premier, you would please find the necessary documents for purposes of settling my daughter's university account.
What page?
That's at 1470. Please note that the annual fees payable after receiving the scholarship is approximately $24,298 US. That's 100,000 rands. The semester amount payable before 31 July 2015 is, however, 12,149. Kindly go to the link provided in the email and use the following access code to pay. And of course, the argument is these monies are all coming from the people who got an irregular contract. So you must come and answer these questions, my lady. This is state money given to an acting judge's daughter. What did she do to deserve that? That when we have toilets in this country, we have put toilets, my lady. Somebody must answer this. A responsible person in power, in authority, has to answer this. And then on top, my lady, I wanted to talk. This is she's writing. I wanted to. I'm sorry. It goes the other way. My lady, just really for the trial court. So, he's then charged with fraud, corruption. Counts 15. 16 deals with MTech systems, with electronic tablets. And the recipients who got it, I'd like to ask them one day, never mind what the law is, my lady, who was your benefactor? Count 17, count 18, count 19 corruption charges. So we go back, my lady. Declaring that the state has not complied with Section 27 of the Prevention and Combating of Corrupt Practices Act, we respectfully submit bespoke legislation. Take your point under Section 106. The court has no jurisdiction. Declaring that Ms.
Sorry,
Choletta...
just hold on a minute, Mr. Kessel.
Sorry? I can charge you. Just mine.
So you're saying that this should be raised in terms of Section 106F in the trial court?
Yes.
Is that your argument?
When he pleads to it. It says that the court has no jurisdiction to try the offense. My learned friend used the word jurisdictional facts on 3 occasions. I think there's merit to his argument, but you're raising it in the wrong forums. Then 2, my lady, declaring that Ms. Moradi Cholata was never a state witness, alternatively is a defense witness. Well, Justice Musi told him on the 3rd of November, he's wasting this court's time with great respect. This is a dead issue. Move on. Oh, we had to hear it again, my lady. But when I come to Ms. Cholata, may I briefly also do my striking of application? Because it really affects her. Now, your ladyship knows that the courts are not keen to deal with striking of applications unless under Rule 612 I can show irrelevant, vexatious, or scandalous allegations. I have to, of course, go further. Even that won't suffice. I have to then show prejudice. So that's the bar I have to climb. And my lady, the leading case there is civil practitioners all know. It's a well-known judgment of Mr. Justice, Chief Justice Mohammed, Danish versus Whitley, 1977-3.
I didn't hear
Beinish, B-E-I-N-A-S-H, the Whitley. Whitley was the chairman of a accounting firm. 1977-3, SA 271, SCA. Very strong bench, my lady. I remember Judge Lienaber, Scott Zulman, Judge Blumen, and the Chief Justice of the judgment. So, why was I inclined to bring that application? Let me tell your ladyship why. If you look at paragraphs 20 to 25, actually 20 to 30 of the applying affidavit of the applicant, you'll see there's a whole saga on Cholota, which is obviously irrelevant.
Just hold on, Mr. Castle, I'm going to get to it. What page are we?
489.
Say again?
489. There's a whole saga about Ms. Cholota. She hasn't given an affidavit, by the way. And my little friend doesn't act for her in these proceedings. But there's a whole affidavit about Cholota, and frankly speaking, it's irrelevant because that issue has been determined. Chief Justice has now moved on. She's now an accused. And my lady, as your ladyship knows, criminal trials evolve. Any litigant feels I've put enough of a prima facie case may refuse to call witnesses. Civil matters is the same thing. You can't bog down the litigator to say, you gave a list of 10 people, you have to call 10 people. And of course, cases change, new evidence come. What is the countervailing fair process right? It's a right not to be taken by surprise. So the judge will say, no. Mr. Nason or Mr. Kessem, you're not bringing in new material. I'm going to give a postponement to the other side. That's how you balance it. Not what my learned friend preached to you yesterday. Oh, well, you can't change your case. I mean, if I'm not charged, my lady, for molesting 3 girls, and very important evidence comes to the fore, of course the prosecutor can introduce it. My lawyer will say, no, I'm taken by surprise. He'll get a postponement. But my lady, what disturbed me was the heads of argument. I want to take you to the heads of argument prepared on behalf of the applicant. And if I'm going to ask your ladyship to turn to paragraph 20.4.
What paragraph?
20.4.
I can't hear you, Mr. Cassim.
20.4, my lady.
If it's just at the noise.
Yes,
you know,
no.
I can't
Your
hear.
ladyship, please.
Paragraph 24.
I have not read all this, my lady, so I'm used to it.
Not considering the age of the court, they say hearing goes with age, and mine's going. So you'll have to pick up the volume.
So, lady, if you go to the heads of argument, 20.4, you will see there, my lady. Of grave concern is what would appear to be dishonesty and the misrepresentation of facts by Advocate Nation and Advocate Nabila Somaru, who are officers of the court and senior members of the NPA. Such conduct is not only unbecoming and worthy of serious censure, but also vindicates the prosecution.
Mr. Cassim, are you reading from
paragraph 20.4?
20. Oh, I thought I heard you say 24. 20.4. Okay, now I'm there.
My lady, 20.5 is in the same tone. And of course, my lady, it doesn't end there. Paragraphs 42 to 57. Same line. I don't want to overemphasize the point. I made the point and move on. Now, you'll see, my lady, you'll see the attack on the dignitas of two high-ranking officials of this division. And of course, my lady, dignitas is seriously viewed in the common law. That's why we have the actu injuriarum's action. But my lady, it also took a propoundment of importance in our new constitution, where it says everyone has the inherent dignity and the right to have the dignity respected and protected. This entire attack is based, my lady, on an interpretation of the email which my learned friend read out to you, where Ms. Cholota says, I have no, let me get that exact wording. Let's get that exact wording. Show you how unfair and unkind our learned friends are. Because when my learned friend started off, he says, I don't attack individuals in court proceedings. I was elated, but he hasn't withdrawn that. I was hoping that he would withdraw it. So when he says, I don't attack, he's an author to those heads of argument. Let me tell you what's it based on, my lady. I hereby acknowledge your correspondence with appreciation. I thank you for the clarification in this regard. It is loud and clear that I do not have any choice. I can assure you of my 100% cooperation in this matter, solely because I respect the law. Now, whatever concocted version is now created in court about Ms. Cholota, we don't know, it's speculation. When you interpret this letter, does it mean that she's saying, I'm a good citizen, and as a good citizen, I want to abide by the law? Is she saying, well, you know, I may not have a choice, because if I don't cooperate, I might be in trouble? Well, I don't know, I don't want to speculate. But the entire criticism, my lady, against the NDPP, who's earned the colors because of merit, against the prosecutor, who's been a staunch civil service all his life, looking after the public interest in this province, they attack their dignitas. And it's irrelevant because Ms. Cholota is not before you. There's no affidavit before you. She's not asking for any relief. So I don't really understand how it connects. That's the really basis of the striking off. It's scandalous on an irrelevant issue. I meet both requirements. That high bar, I cross it over and over. So then, my lady, I want to make progress, and I take you to what they're looking at, the third relief they seek. Now they say, declaring the state's conduct, insofar as Ms. Cholota is concerned, in or the manner in which the prosecution...
Where are you reading from now?
Paragraph 3 of the notice of motion.
3 of the notice of motion.
I've dealt with 1 and 2, my lady. There's no merit in 1 and 2. Absolutely no merit. 3. Declaring that the state's conduct, insofar as Ms. Cholota is concerned, in or the manner in which the prosecution has been conducted, 2. Prima facie constitutes procedural misconduct. Never have I seen this before, my lady. I look young, but I've been in practice over 40 years, my lady. Prima facie procedural misconduct. What has that got to do with this court's great respect business? Either you're dishonest, or you're not honest, or you're honest. You can't be prima facie procedural misconduct. Are they asking your ladyship to give an opinion here which will form the basis of further proceedings? Your ladyship will never do that. I'll tell your ladyship why. Because the entire case is made out in the reply. And what's worse, you're asking for relief against people, my lady, who are not joined to this application. Mr. Nation and Ms. Samora are not parties to this application. And they want a prima facie finding against them. They were up in arms, and I told them, please, don't do a rejoinder to the reply, because they can't make out a case in the reply. And if you want to enter the arena, you've got to bring a substantive application, ask for a joinder. And why do you want to do that? And they're persisting with this relief. Then it comes, my lady, declaring that the applicant accused was not an executive authority at the relevant time as defined in 1B of Public Finance Management Act. Now there, my lady, again, one is perturbed. I'll tell you why one is perturbed, my lady. If you go to my practice note, my lady, where I thought I summed up this entire case, I thought so, my lady, but certainly not taken seriously by my learned clients, by my learned opposition. In paragraph 19, my lady,
19.
of my practice
Sorry,
note,
19, Mr.
19. Oh, sorry, before I go to that point, my lady, insofar as prosecutorial, prima facie prosecutorial misconduct is concerned, I'll urge your lady to please revisit what I said in paragraph 18, the judgment of Mr. Justice Kuhn,
18 of what?
of my practice. I say there, my lady. Secondly, in dealing with public prosecutors, their professional enthusiasm in the prosecution they pursue, believing passionately in their cause and pursuing it with all the zest and zeal of a dedicated and conscientious prosecutor presenting the case of the state and the general populace, and to the extent being perceived as not independent and objective, does not result in a lack of title to prosecute. Kuhn J. in State v. Zuma. I mean, prosecutors do a job, my lady. As my learned friends feel for their clients, prosecutors feel for the public. I should hope so, my lady. That they passionately burn the midnight oil to do what is right, to put all the true facts before them. Then, my lady, I now come to, thirdly, our learned friends persist with the allegation that accused number 13 is charged under PFMA Act. We have read the charge and studied its context. He is not charged under PFMA. And if you go to the heads of argument, you'll see in paragraph 32, they persist.
That's their heads of
Their heads, look at their heads. 32, they persist. And I invite them to show me where he's charged under PFMA Act. When I'm dealing with executive authority, I've already pointed out to you the precepts of the Constitution in section 125. But there are two aspects relevant to the position of the Premier in the preamble. And if my learned junior can give me the page numbers, I have a note in my notes, my lady. Page 330.
336, I think.
I have it in my name. 330 in the preamble.
Your indictment starts on 322. So you can look from there.
Yeah, so I'm at 330. My junior can just look for the other one. That deals with the directive. So the first link, my lady, is the following, and I'll read it. At the top of 330, I also have it is ESM 14 in brackets 2.
Just a minute. Page 330, you say?
330, my lady.
And which part of it?
Right on the top.
Oh, section 136.
Is an attorney with right of appearance in the High Court. I think that's Mr. Fenton, is it right? Yeah. And also the head of the legal department in the office of the Premier.
Wait a minute, Mr. Kassam, I don't think we're on the same page. I'm looking at the top of page 330, and it starts section 136 of the Constitution, deals with the conduct of members of the Executive Council. So we are literally not on the same page.
No, we're not. But my lady, can I ask you, it's the last page before counts 1 to 8.
And what does the paragraph start? How does it start?
Accused 16.
Ah, yes.
Thank
That's
you,
338 in my papers.
Thank you, my lady.
Yes, you may proceed.
When I was a junior, I know my senior would have blamed me for that. But I don't do that anymore because I have two juniors who scream at me. So, accused 16 is an attorney with right of appearance in the High Court and also the head of the legal department in the office of the Premier. Accused 13. He had intimate knowledge of all the procurement contracts in accordance with directive issued by the office of the Premier. Accused number 13. All such contracts should be evaluated by legal department. He had knowledge of the notice of possible court action against the department and subsequent action in the Free State. Serious allegations were made by the appellants amounting to inter alia dishonesty, etc. So the point I'm making, my lady, he was in the office of the Premier. So the Premier will have a monumental task to say, I didn't know what was happening. If he said, look, I didn't know what was happening, it will impact on his leadership qualities. And there's another aspect, my lady, in the preamble, my lady, which links him in his position as the highest ranking public official at the relevant time when this alleged fraud took place in the province. And that your ladyship will find, and again I hope I got the right page number, 329. On 26 June 2014,
Yes. Accused 13 delivered the state of the province.
that's the one, man. Yeah, then your ladyship knows it. In his speech, he made mention of the eradication of asbestos roofing project in the Free State, which should take place from 2014 to 2019. We know, my lady, before they even started, they were paid 52 million.
Sorry, I didn't hear that, Mr. Cassim said.
We know, my lady, it's now a common cause in all civil proceedings that before they even started, they were paid 52 million. He says 2014 to 2019. So he cannot say I didn't have knowledge. He cannot distance himself from the government and the material essentials of a fraud perpetrated on the people of this province. He cannot. Two clear instances arising from the preamble. And my learned friend said to us, an accused is entitled to know what his case is. Well, that's part of our law. We accept that. But if he doesn't know what the case is, you can't put the blame on us, man. You must just read that preamble more carefully, as I did. So, paragraph 4.
Just a minute. Sorry, just a minute. Yes, thank you.
So paragraph 4 of the notice of motion is meaningless. My little friend, when he read out my heads of argument, he says my heads were nonsense. I don't want to say it's nonsense, it's something meaningless. No court's going to give this kind, you exercise a discretion, my lady, you're not going to give that kind of order. So what are we left with? We're left with 5. Compelling the state to disclose the list of witnesses which specifically implicate the accused, 13, in any and all of the charges as contained and listed in the indictment. That, of course, is new law. What section 144 of the Criminal Procedure Act says, I must give you a list of all my witnesses, which they were given together with the indictment. We could not come across any case, nor have our learned friends cited any authority to make new law that I must now tell accused number 1. These are the following witnesses who give evidence against you from the list of 30 witnesses. This is simply, they're not asking your ladyship to make law, they're asking your ladyship to make new law. It's part of a discretionary power. And then, my lady, declaring that the applicant is entitled to know the case that is required to meet before he pleads. Of course, my lady.
So just give me a minute, Mr.
Sure.
Cassim, just a minute.
There, my ladyship won't give an opinion on the law, because ultimately these are declaratory orders, and your ladyship will have regard to the 3 authorities which I've cited in my practice note at page 10, starting with Radio Pretoria versus the Chairman, Independent Communications Authority. Courts will not decide issues of academic interest only. Rainwater Board versus ROLAC. Courts will not make determinations that will have no practical effect. National Coalition for Gay and Lesbian Equality versus Minister of Home Affairs. The case is moot and therefore not justifiable. Justiciable. Thank you. If it no longer presents an existing or live controversy, it should exist if the court is to avoid.
So should that word be justiciable and not justifiable?
Yes, my lady. I'm a product of a primary school learning Afrikaans. If the court is to avoid giving advisory opinions on abstract propositions of law. Now, what they say is, they come to court and they ask for this relief, my lady. And 35.3 says, my lady, of the Constitution, every accused person has a right to a fair trial and includes to be informed of the charge with sufficient detail to answer it. If you're not happy with the detail, request further particulars. So they can't get that. Then, declaring that the state does not have a prima facie case against accused 13, which is capable of sustaining a successful prosecution. I'll put the rhetorical question. How dare they do that to a court? When they themselves haven't read the docket properly, nor the charge sheet, because if they read the charge sheet, they know they're not charged under the PFMA Act. If they read the docket properly, they know when they said to your ladyship, we caught them. He was only told of Section 34. That's not right. We showed you the warrant of arrest. We can hand it up to ladyship if I didn't, for your convenience, because I don't expect your ladyship now to go search the docket. I'll hand it up to your ladyship. A99.
It has been included, has it not?
Sorry?
Is it not been included in the docket?
Of course it's in the docket.
Papers, I mean.
Yes, my lady. In the docket it is. We gave him the docket.
Now, what I'm saying is, it's not in the papers.
Most of the documents referred to the trial.
Okay, well, probably that's why I was wondering whether I fell asleep while reading the papers,
No.
because I don't recall seeing it.
So how can you ask your ladyship to make a finding like what's in paragraph 7? What they want is your ladyship is to review all the papers, thousands of pages, to review it without oral evidence to make a prima facie finding. How can your ladyship do that? Unheard of. I don't want to say novel, I want to say to your ladyship, simply inept in the fullest extent. My lady, it is this application that I can with conviction say to your ladyship, you should dismiss it with 3 counsels first. Because of the conduct, my lady, in an attack on dignitas of people, when it's unnecessary. If they want to report them to whoever they want to, they're free to do so, but not in this application. Not to get political mileage in this application. Finally, my lady, I have made the point, my lady, in my practice note and in our heads of argument, my lady. If your ladyship will go to paragraph 17 of my practice note, where I say first, the SCA held that findings of political interference are irrelevant to the decision to prosecute, stating that a prosecution is not wrongful because it is brought for an improper purpose, but that it will only be wrongful if, in additional, reasonable and probable grounds for prosecution are absent. The motive behind the prosecution being irrelevant. And of course, my lady, one of our finest judges, Shiner, put in the following: the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. Of course, that also applies to prosecutions. Those are our submissions, my lady. I'm afraid, my lady, I accept more than to my family.
Are you wanting to address further on the striking out application?
No, my lady, I've dealt with it.
And the one for Mr. Sodi, because it's the you hadn't dealt with that or not?
The same principles apply. Of course, in that case, I did say, my lady, I made one additional point there. I said, applications, my lady, invariably involve facts and evidence. Actions, my lady, trial proposition is facts. I did complain, my lady, that you're giving extracts from cases in your founding affidavit. Now, what is the implication of that? When we're having this development, my lady, that more and more one sees what's creeping into founding affidavits, particularly in footnotes, is reference to cases. Is it a suggestion that the court doesn't read law reports? Is it a suggestion that the court doesn't understand the cases, so you explain it and then you give a case like argument? It's a very dangerous precedent, talking about pleadings, my lady. And of course I took that point there. I feel strongly about it, but in the end I make nothing about it because I know there's no prejudice. The court will know you can't take an extract from one case and put it in your founding papers, each case on its own facts. So there I'm weak, my lady, on the relevancy, because when I read the Bailey's judgment last night, Mr. Justice Mohammed pointed out that you cannot fool the courts. The courts know the law. So my relevancy point there is weak. But the principle applies. I mean, we feel offended by calling my team dishonest. We don't understand the case and all kinds of things. It's not right. Don't practice like that. This matter has really gone completely out of course in the tenor and tone of pleadings. In the tenor of tones what appears in the heads of argument. That people are so passionate about it, my lady, should not deter forensic analytical analysis of the facts in the law. That's what we lawyers do. We don't cross the line. There's the point. Unless, my lady. Those are our submissions.
Thank you, my lady. Thank you, my lady. My learned friend began by putting somewhat of a sugar coating around his address by referring to our personal relationship. I have no intention of doing so, my lady. What is apparent, my lady, as your ladyship has just pointed out, is that he's referred to documents that are not part of these papers. So despite our friendship and personal relationships, when as regard to the law, the court is enjoined to apply the law. There's a lot of authority going back even to the 60s, my lady, that one cannot come before the court and start referring to documents that do not form part of the papers before the court. As he told your ladyship, as good as he looks, after his 40 years of practice, he still ought to know the law. The authority is clear on that, my lady. To start handing up the warrant of arrest now that was never part of the papers, which was also the beginning of his statement, doesn't make out the case, my lady. And the facts are the facts. The papers are before your ladyship. They had the time frame that was given to them by the judge president.
So do I understand you to mean that you object to the handing up of these documents?
Definitely, my lady. It's totally irregular. It's improper. It was never shown to me in advance. It's not the case to be made up.
And is it part of the docket that was handed to your clients?
Yes, my lady. Part of the docket. It isn't part of these papers, my lady. It's not part of the case. And it shows with respect and inexperience in criminal procedure, because we know, my lady, that the application for a warrant of arrest is filed by the investigating officer at the magistrate. It doesn't go to the accused. So to now refer to it isn't only improper in these circumstances, but it's irregular, and it has no practical meaning. Because the procedure followed, my lady, is that the accused, in this instance, was called on the papers, on everybody's version, to present himself. He was never shown the application for the warrant for his arrest. That was subsequently given, my lady, in the docket that was received as part of the A clip. Let me make that very, very clear, my lady, as they were obliged to do when they made the disclosure of the information. One cannot now rely on that document, my lady, to say, well, he knew the charges against him at the time of his arrest, so this now clarifies everything and makes it all good. It shows an inexperience in that field of the law, my lady. And your ladyship knows, having worked as a magistrate previously, that that's not given to an accused person. Similarly, my lady, to argue that he was given an opportunity to explain because in the arrest process he filled out a warning statement. It doesn't cure the problem, my lady. It doesn't, and he knows it. Or he ought to know it, or the people advising him do know it. There can be no question about that, my lady. So with respect, to hand that document up now doesn't serve any purpose. Like saying, oh well, you ought to have known because subsequently I told you the following. It does not cure the problem because section 27 says, and only after. I've said it so many times, and he hasn't answered any of the statements that I've made to your ladyship. But let's go one step further, if I may not. Not only does the warning statement not form part of these papers, the warning statement doesn't cure the problem. The application for warrant of arrest doesn't cure it either. So it's wonderful to refer to a document out of context that isn't even before your ladyship, but it does not solve the problem of and only before. Now, my lady, I'm going to go one step further because it gets even worse with respect. To now change the case, my lady, from a plea in terms of 1061F, I beg your pardon, to 1061F, my lady, doesn't solve the problem because when somebody pleads that the court lacks jurisdiction, what's the relief, my lady? The matter gets adjourned to the court that does have jurisdiction. It's a territorial issue, my lady. It's not a legal argument. So in criminal procedure, as my learned friend ought to know, if an accused person does not object to the jurisdiction of a court, it's presumed that the court has jurisdiction. If the accused raises a plea of lack of jurisdiction in terms of 1061F, which is now belatedly placing before your ladyship, it doesn't appear anywhere on the papers, my lady. It's again a new issue, my lady. It doesn't appear on the papers. 1061F says the court lacks jurisdiction. My lady, if the court lacks jurisdiction, the cases are clear. The relief that the court grants is it postpones the matter to the court that has jurisdiction. That would never resolve the problem pertaining to the certificate. So we have 1061F. When an accused pleads to charge, he may plead one, that the court has no jurisdiction to try the offence. So if I have a matter, even in this court, my lady, and it took place in Johannesburg, so possibly with the argument here is that the Premier was in Johannesburg when all of this happened, so the correct court to hear the matter would be the Johannesburg High Court. That would be a 1061F plea. Nothing to do with what we're dealing with here with respect, my lady. And your ladyship knows that. We have it regularly in the magistrates' courts, and we even have a process now, my lady, where the DPP's office can certify that the court has jurisdiction in cases where there are multiple charges from several jurisdictions, then you have a certification that the court has jurisdiction. That's what 1061F deals with, my lady. Not this situation, my lady. So not only does it not appear on the papers, my lady, it's a new argument, and with respect, it doesn't match the case that they have to meet. It's not a solution. The issue here, my lady, is that the point raised is unanswerable on the facts. It's as simple as that. So we can look around all the possible pleas, my lady, but there isn't, fortunately for us and unfortunately for my friend, a catch-all phrase where you can raise any type of a plea in front of a court because it doesn't exist in a criminal trial. The procedure is regulated by the statute, being the Code or the Criminal Procedure Act. It doesn't go beyond that. So one cannot raise this issue as in the form of a plea, my lady, and it would be ridiculous with respect to all persons to expect somebody to go through a whole trial only to find out after months and months of trial that this requirement has not been met. There's no basis to do that, my lady. So, as to the possible plea and the non-compliance with Section 27, they have not answered the case put up by the applicant, my lady. To argue then that it's in the public interest and I represent the public interest does not extend the jurisdiction of the court beyond the Criminal Procedure Act. It can never make out a different case. The court must apply the supreme law of the land, being the Constitution. There is no way out of it on the basis of public interest. The closest one gets, my lady, is Section 36 of the Constitution, which makes it still a requirement that has to be justifiable in a free and democratic society when one has some type of invasion, which is not his argument and has never been made out of it. Now, my lady, to then go to what my learned friend says makes out a solid case on the papers, and I'm going to apply the label back to him to show just how opportunistic it is, my lady. I'm going to refer you to the very papers that you referred your ladyship to, and in which he says the case is made out of corruption. Let me show you the emails. I want to show you, ladyship, that the emails do not make out such a case. And that's why the accused, and I said in the exceptional circumstances of this case, is entitled to the relief sought. My lady, the starting point is the very page that my learned friend referred you to, page 470.
400 and? Sorry, what page?
470, my lady. At page 470, leading to page 471, we have what was annexed to Ms. Chilota's email. You'll see that in order there, you'll see it's AA2 and AA3. They were attached to AA1. It goes as follows. We have to read them in reverse order. So the first email, and I'll show you, ladyship, also, it is at the foot of page 470. Lady, it's an email dated the 17th of July 2015, and the time that's allocated to is 11:50 a.m. It's an email from Refaluwe Mokoena to the Premier's official email address, which is dealt with in some statements, my lady. It's an official email address, premier@fspremier.gov.za. It's an official email, my lady. There's nothing hidden, sinister, or untoward about it. And let's go through it, my lady, because a lot was made of the fact that your ladyship even corrected. Thank you from the bottom of our hearts for your assistance. I have no doubt that my daughter will make good use of this opportunity. God bless Refaluwe Mokoena and her cell phone number. My lady, it's a student who's going overseas to study. How this satisfies corruption is beyond me. But let's go one step further and let's look at all of the evidence in case I'm just being too polite to my client, but I don't find anything sinister in that with respect. The next email is at the head of that page, my lady, some 10 days later. And this is from Ms. Chilota. It's Muradi Chilota, Monday 27th of July 2015 at 14:45 and 16 seconds. And it goes to mapisalefu@gmail.com. Subject is Laka Doc 2. And then it says, Ntate Mapisa. I wanted to talk to Chief regarding the below. He reached an agreement with Advocate Refaluwe Mokoena to pay her daughter's fees. I checked, the school is accredited and payment needs to be done before FRD the 31st July. US dollars 12,149. times 1266 is rands, 153,806 rands and 34 cents. Please help me, my brother. Regards, Murawadi Chilota. I don't even know how that impacts on the Premier or on the applicant, but let's complete the picture, my ladies, so that we don't mislead anybody. And let's turn to the next page, which is AA3. Here we have on the 18th of August 2015 at 10:56, an email from Refuwena Mokwena to Murawadi Choloto, subject repayment. Dear Murawadi, many thanks for all your patience and kindest assistance. On behalf of my family, I take this opportunity to thank every one of you. Let me pause, my lady. To thank every one of you, I'm repeating myself, my lady, who made the generous contribution towards my daughter's fees. Please communicate my heartfelt appreciation to the Premier and the donors. I'm truly grateful to the Premier for making it happen. Super blessings sent from my iPad. Then you'll see at the bottom there, good morning, kindly find the second proof of payment for $4,000. Regards, Murawadi Choloto. But lady, I know that the offence of corruption is very, very wide, and there was a mistake made that it's a common law offence. It's not. We have a statutory offence. It's where somebody promises somebody something, undertakes to do something, or even gives the impression that they'll do something on the basis of the office that the person holds. I don't read that into these emails with respect, man. And this proves why we need to know what the case is. You cannot, without more, as my learned friend tries to do, read more into this, my lady. Here are the emails. There's nothing sinister with respect to a student. She can be from any home, my lady, who qualifies for a bursary and goes overseas to study. In fact, I must say, if my learned friend was giving evidence as he did, it's quite commendable. If that's what you believe in, the future of people that qualify to study overseas, and it's sponsored by several people. But I don't read into this with respect a charge of corruption, a charge of Section 34. It doesn't read the way my learned friend wants to read it, my lady. It just doesn't. The picture tells the story of 1,000 words. There are the actual documents, my lady, without more. I don't see the offence. If, on the other hand, my lady, they could say that, and in return, the advocate did the following, or and in return, the acting judge made the following rulings. But it doesn't appear, my lady. Oh, but now you must rather just ignore everything because it's in the public interest. Let's put a man on trial because he's an accused person, and we're going to act in the public interest and see what that results in. It's no justification with respect, my lady. Your ladyship will bear with me. My lady. If one has regard now, because I understand that this is the opposite time, to the actual striking out application.
Sorry, Mr. You've gone very soft.
I
I couldn't hear you.
apologize. To the actual striking out application that's before this honourable court, my lady. And that's, as we're obliged to do, my lady, deal with the actual papers. Let's not go beyond the papers and start finding possible explanations and excuses extraneous of the documents. So, my lady, the application begins, and I'm going to take you through it, but it's not very long, my lady. At page 1152. In our papers, my lady, it's the third file. Let's deal with this one. Ladyship will see. I'll wait for you then.
It's 1155 in my papers. There was
I don't
clearly
know,
some...
my lady, I'm going to use my junior's page references too, but I will find it. I beg your pardon, I don't know how that happened.
Well, what had happened is in the so-called corrected bundle that was sent to me, the index was omitted, so therefore
Oh, the 3
already
pages
the,
of books.
yes, and then there was another page that was wrongly numbered. The 2 pages bore the same number. So
Thank you, my lady. If I may then refer you to 1155, I apologize for everything, and you'll see that it's that at the hearing of this matter there will be an application for the striking out. The paragraphs are detailed there in the affidavits of Elias Sekopelo Magashule and in paragraphs 1 and 2. Then, my lady, we begin on page 1156. Where there's where they say here in paragraph 5.1, the last they say the contents of this paragraph are irrelevant to the issues before the court and unduly prejudicial to the state. I submit if there was any political interference in the prosecution of Magashule which is denied, and in any event none has been established on the papers, this is irrelevant to the decision to prosecute. Now that in itself, my lady, you only have to state to realize is not correct. Okay? And then they continue, my lady. A prosecution is not wrongful merely because it is brought for an improper purpose. Now, my lady, act in the public interest, act in any interest. You can never justify a prosecution brought for an improper purpose, where the obligation on a prosecutor is to act without fear, without favour, and without prejudice. It goes against the grain, my lady, of everything that a prosecutor is required to do. This is the case they make out, my lady, in their founding papers. I'll continue, my lady. 5.2, as Mr. Cassin even said, the ultimate test is whether there are reasonable and probable grounds for prosecution. Motive is irrelevant. My lady, that doesn't fit into what we know or the ethical obligations, as in many, many cases, my lady, of a public prosecutor, as per their own directives, as per their own practice, that they have to act without fear, favour, or prejudice. And that's the case made out by the applicant here, and I'm going to show you from the timing, my lady, which has been the crux of everything I've argued to you, just how sinister it is, in order to prove that this is politically motivated and unsustainable and ought not to be condoned by any court, my lady. If you turn the page, my lady, to paragraph 7.3. In our papers also, it's page 1158.
mine is 1161.
Paragraph 7.3. I also point out that in adversarial criminal proceedings, such as ours, it is inevitable that prosecutors will be partisan. My lady, I want to draw on my experience, but if your ladyship, acting as a senior judge, is prepared to condone such conduct and hold that the state, and I'm using it collectively, my lady, is entitled to prosecute and be partisan in doing so in a matter that is so obviously politically inspired, that then my submission, my lady, is that could never ever be in the public interest, or even worse, justifiable in law. That's the case they seek to make out, my lady. That your ladyship should uphold the prosecution's right to be partisan. Their terminology, not ours, but it's not something I attribute to them. It's something that, with respect, my lady, I'm incapable of sugarcoating. Then, my lady, I will refer you, and I'm going to try to get the pages right, to the answering affidavit that's then filed by the applicant in the striking out application.
Just refer me to the paragraphs.
As your ladyship do. Thank you, my lady. I appreciate that. Thank you. My lady, at paragraph 4 of the applicant's affidavit, he says, this affidavit is in opposition of the state, in inverted commas and in brackets, applicant's application to strike out certain paragraphs of my founding affidavit and replying affidavit, since the paragraphs concerned are relevant are not vexatious or scandalous and certainly do not prejudice the applicant whatsoever. My lady, there's nothing that's not relevant in our papers. There's nothing that's vexatious or scandalous, and there's nothing prejudicial. In fact, my lady, it would be best described as being the truth, as your ladyship has seen from the transcripts that I've referred to being the source documents of the submissions that are then made. In paragraph 10, as my learned friend referred to, under the heading No Substance to the Application to Strike Out, it says, the application to strike out is an attempt to suppress my assertion that my prosecution is animated by an ulterior political motive, to sever my quotation of in reference to certain case law and affidavit, and my assertion that Advocate the Nation has made certain dishonest misrepresentations concerning Ms. Charlotta being a state witness, among other things, as endorsed by Advocate Samaru as the department's answering affidavit. My lady, the word dishonest comes from the words of the Judge President. It's on the record, my lady. It's not our words. I even said I wouldn't put it that strongly, but there it is. If I may ask your ladyship to turn then to paragraph 19 and following.
Sorry, paragraph?
19, 19, my lady. If we may start at 18, my lady. It says, in the applicant's answering affidavit, rather than dealing with this gross irregularity and misrepresentation, the applicant states as follows. And there's a quote, 83 at paragraph 56. This is respectfully denied. The allegation constitutes a clutching by Magashule. 19. In essence, the applicant entered a bare denial and found paragraph 56 of my finding affidavit to be rather desperate, colloquially speaking. 20. It now claims that this allegation is irrelevant and prejudicial to the state. Which is it? Desperate or irrelevant and prejudicial? The state cannot approbate and reprobate. So, my lady, they answered the allegations, they dealt with it, and then subsequently put in the application to strike out once they'd already dealt with the issues. 21. There was certainly no prejudice claimed at the time that the answering affidavit was filed, presumably with good reason. 22. Astonishingly, the applicant, while claiming that the allegation of political interference is irrelevant and unduly prejudicial, also claims that a prosecution is not wrongful merely because it is brought for an improper purpose. The mutually destructive versions of the state need only be stated to be rejected. In addition, the applicant claims that it is open to the prosecution to be, quote, partisan. I'll deal with the latter issue later in this affidavit. If I may ask your ladyship to turn to paragraph 45. It's headed at paragraph 7.3. It says, while I admit that criminal proceedings are adversarial in nature, I dispute that it is open to prosecutors to be partisan. Ethically, prosecutors are required to act without fear, favor, or prejudice as espoused in the prosecution policy. In fact, the assertion that prosecutors are partisan leads credence to my averment of ulterior political motive driving the prosecution and is a startling concession to say the least. Lady, that would be a high note to end my address, but I would be failing my duty to my clients to not point out the following. If regard is had to the following objective factors, I had foreshadowed my reply, my lady, and that is the time. The timing in this matter is extremely sinister when regard is had to those statements, my lady. Let's just start from the beginning and get to the end and where we are. Dealing only with dates, my lady. Firstly, my lady, the investigations began very late. As your ladyship knows, the investigation diary starts on 10 October 2020. That has no bearing whatsoever, my lady, to the events that were dealt with in the indictment that my friend refers to. The ladyship has seen the emails, the time frame, they set out in the indictment, my lady. Then, my lady, we know that the state was too quick to arrest. Why do we say that, my lady? Because they didn't have the investigation completed, which in itself is unusual. But we know that, as I quoted in State versus Bennett. Additionally, my lady, we know that the states of Mr. Lotta had not been resolved. On 13